I could ever describe myself. So thank you very much. Thanks for having me. As Jennifer said, we live in a very digital world these days, and as a result, there is all sorts of considerations when it comes to your clients' and customers' privacy. And what this session is going to hopefully cover, if I'm doing it correctly, is what you as businesses need to do in order to remain compliant with the current legislation. So, without further ado, I will get right into it. The one weird thing about these Zoom presentations is, as funny as I'd like to think that I am, it's a little bit strange because I can't actually see you, I can't hear you, but I'll just assume that every joke that I make is hitting and you're all laughing hysterically, and it'll make me feel better about this presentation. So just so you know where my head's at during this entire thing. So we'll start with the history and what the government has kind of done in order to protect customers when it comes to their privacy. So in the 60s and 70s, the framework for the internet was coming about. The first email was sent in 1971. The first spam email was actually sent in 1978. And then in true legal and lawyerly fashion, in speedy response to this 1978 spam email, the Canadian government 30 years later came up with PIPEDA, and another 10 years later they came out with CASL. So PIPEDA is the Personal Information Protection and Electronic Documents Act, and CASL is the Canadian anti-spam legislation. You can think of them relating to each other in the sense that PIPEDA was the firstborn child of the Canadian government, where they got most things right, but they forgot to do a couple things, most specifically telling us what we weren't supposed to do. And so I'm going to talk about both of them kind of generally now, and then we'll go into more of the specifics of CASL. So PIPEDA generally deals with how businesses need to be accountable for how they collect, use, and disclose individuals and business personal information. This includes emails, specifically in the course of commercial activity. Businesses also need to make sure that they obtain all of that information with consent, even if you get them from a third-party supplier. The final kind of general aspect to PIPEDA is that once you have all of that information, that business has to take certain measures in order to protect that information that are reasonable steps, so that you're not just handing it out on the street, or you're not going to be susceptible to somebody else taking that information away from the business that you have that has collected this information. So what PIPEDA forgot to do, or I guess the Canadian government forgot to do, is it forgot to tell us all the things that we shouldn't be doing with that information. So CASL put in restrictions on how and what we're supposed to be doing with that information specific to commercial activity. So CASL restricts us from sending commercial electronic messages, including emails, social media, and text messages, without consent. It also restricts us from altering transmission data in an electronic message so that the message is sent to a different destination without your express consent. It also restricts installing software in certain circumstances. We can dive further into this kind of later on in the presentation, but there are certain circumstances where it's okay and where it's not okay. It certainly restricts gathering personal information, including emails, legally, as well as harvesting addresses. So this is usually done through a third party. You hire somebody or a program to collect email addresses off the web in order for you to send commercial electronic messages. And so this act basically restricts all the things you can do and the steps you have to take in order to become compliant. So it is your responsibility as a business owner to confirm that you are CASL compliant. If you are not CASL compliant, there are 3 government agencies that are going to be breathing down your neck. There's the Canadian Radio, Television and Telecommunications Commission. There's the Competition Bureau, and there's the Office of the Privacy Commissioner of Canada. Now, each one of those is going to cover a specific area. Usually the Competition Bureau is dealing with the business-to-business aspect of it. Usually the Office of the Privacy Commissioner is dealing with infractions of invasion of privacy of individuals or businesses. And the CRTC is actually governing your communications. So usually dealing with mass emails and things like that, that's what they're going to be looking at. All 3 of these agencies have a reporting service, so it becomes very easy for individuals or other businesses to report issues with non-CASL compliance. When I wanted to start this presentation at, it's a little bit of a scare tactic, partially. I wanted to make sure that I was not going to be the guy who presented to the person who actually had one of these terrible penalties handed out to them. So I want to make sure that you're paying attention right off the bat. So CASL, they have a STEPS program, and it's usually warranted based off of how severe the infraction is, whether you as a business has personally benefited from it, and truly just the nature of the activity that caused the infraction. So in the best case scenario, you get a warning letter from one of the agencies, or you get a negotiated agreement where there's certain conditions that you have to fulfill, saying that you won't do certain things. In the worst case scenario, there's up to criminal sanctions, and so that's why we want to avoid this at all costs. The very concerning things is these things called AMPs. And AMPs are administrative monetary penalties. And it's a fancy legal way to say something that's gonna make you feel real bad in your wallet if you cause an infraction or a contravention of the provisions of CASL. For individuals, the penalty can range all the way up to $1 million, and for businesses, it can range all the way up to 10 million. Now, that's a very scary way to say, make sure you are CASL compliant. Now, I will say that in looking in at some of the case law, nobody has actually been charged the $1 million for an individual or $10 million for a business. But I mean, specifically because I'm presenting to all of you, I would prefer it if one of you was not the guinea pig that got the $1 million and $10 million awards. A final aspect that was very recently put into CASL was that individuals can seek private action against any sort of company that sends them a non-compliant CASL message or a CEM. And that basically means that each individual person has the ability to claim and doesn't have to necessarily go through the government reporting services. The bar is very high in order to do so, but it doesn't mean that you aren't going to be dragged through all sorts of legal costs and legal battles in order to deal with that issue. Now that I've scared you about how serious CASL compliance is, we'll talk a little bit more about exactly what CASL requires you to do. So your first question is going to be, is this message I am sending a commercial electronic message, or a CEM? And is it going to be received in Canada? So for starters, if you're sending messages to other countries, the Canadian government doesn't care about you. We don't care. It's only the ones that are received in Canada. The determination as to whether you are sending a commercial electronic message, it seems pretty self-explanatory, but there are all sorts of ins and outs. But generally, it's anything where you're trying to get somebody to purchase, sell, barter, lease, provide them with a service or any sort of interest, whether you're promoting a person or providing them with some sort of opportunity. Anything having to do with money, truly. That's what we're concerned about here. And so what you have to consider here is that while there are so many messages that everybody sends on a day-to-day basis that might fall under that CEM category, there are certain exceptions. The biggest one that I want to kind of highlight here is the business-to-business exception. If you send a CEM to another business, that is falling under an exception, and it would be okay to do so long as there is an existing relationship between the companies. And that's not, that doesn't mean, oh, I once purchased a Coke, so therefore I have an existing relationship with Coca-Cola. I wish that was how it worked. That's not how it works. It can't be my friend's daughter's taxi driver's cousin knows somebody at the company. That's not an existing relationship. There has to be something more than that. And what is going to be the key in any of these circumstances, and it's going to become a big theme that you'll see reoccurring through this, is that you're going to have to prove it. So if you send a message and somebody complains and you say, no, 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 I have a relationship with them, that governing agency is going to ask you to prove it. Say why you have an existing relationship and how that came about. The other exceptions that you can keep in mind is your family and friends fall under an exemption. So you can spam your family and friends. That's totally okay. They can become as annoyed with you as possibly can be. The other things that you can send CEMs related to are if you get a requested quote from somebody, if you have a product that you have to provide warranty information to a customer, if your customer subscribes to your product or service, as well as for within your company, if you are sending any message to your employees for their benefit. So whether that's an employee benefit program or whether it's something that they're entitled to, those don't count as, or they fall under an exception. So, in order to be CASL compliant, it seems very, very simple, but you need truly 3 things. You need to obtain consent, you need to provide identification information, and you need to provide an unsubscribe mechanism. So we're going to dive into 1 and 3 in a little bit, but I'm just going to quickly talk about number 2 rather. In order to properly identify yourself in your CEM, you have to identify yourself as well as any other parties the CEM is becoming on behalf of. So if you're operating in association with another company and you're doing joint marketing, you have to say both companies. It becomes a little bit more confusing when you've got parent companies versus subsidiaries. But the key takeaway there is to always err on the side of caution and mention everybody. So whether that's through an advertising name on the top, or by providing a link to each of the company's websites, that's a way that you can do that. So this is by far the most, I want to say, complicated aspect of CASL, is consent. Consent is complicated in the way that they've drafted this statute, is that you can get consent in two ways: express as well as implied. Express is pretty self-explanatory. There's certain requirements, but it means that somebody has taken an overt action in order to say that they want you to send them a CEM. And if there is no express action, then you're going to be relying on implied at best. The benefit of express consent is that express consent lasts forever. So if I obtain express consent, which we'll talk about how to obtain that, I will be able to send them, that client or customer, a CEM for as long as they don't unsubscribe. The one thing to keep in mind with that is that an email asking a client if they want to opt in to CEM is against the rules. You're skipping step one. So you always have to get that consent. So an email asking for consent has already stepped past step one. So then we run into the implied circumstances. Implied is much more complicated, and it kind of deals with what we were talking about previously about the business-to-business exceptions. And the business-to-business exception talked mostly about existing relationships. And existing relationships have to be, they're defined within the Act. And so there's a couple questions that you can ask yourself if you have an existing business relationship. Oh, does somebody ask a question?
Yeah, it's just a simple one, actually. Does CASL replace PIPEDA, or are they read in conjunction to one another?
They're read in conjunction to one another. So there is no replacement. It's just read in conjunction.
Okay. And actually, we do have another question.
Sure.
So somebody is, with that, all of that consent versus implied, I definitely see where this question's coming from. So they've asked, does that mean I can't send out a cold email to a targeted customer?
So yes, it does restrict that unless you have a existing relationship. There are ways to get around that, however. Cold calls are not restricted, whereas cold emails are. So a beneficial way for you to go about it is to go first by phone, and if you get consent there, then send your email. And what you should do is always reference your phone call within that email. So if I called up Jennifer and asked her whether she wanted some legal services, and finally she said, yes, you've worn me down, I would then send her an email and say, Jennifer, pursuant to our conversation of this date, we discussed our mutual interest in starting a business relationship. Here's my pitch. So yes, the short answer is yes, you cannot send a cold email.
Okay.
Does that cover off all our questions?
They're coming in now. The floodgates have opened. We got to the consent, implied, express,
I knew it was coming. I knew it was coming.
So Connie's asked, are NFPs, not-for-profit / charities exempt from the B2B exemption if no dollar is being asked for? For example, just info update, and what if dollar donation is being asked for? So basically, I think just like that general outreach for.
Yeah, so there's a very specific section on not-for-profits. Now, I don't know offhand, there is a very specific line as to what they can and cannot say in a cold email asking for donations, or whether there isn't any donations. I can kind of deal with that offline after the fact. And if whoever it was, did you say Nancy? Is that
that one was from Connie? So yeah, Connie, if you want to hang back for a bit after.
I'd be happy to talk to you about that after the fact.
Great. Okay. So Cameron, he says if it's going to be discussed later, then we can circle back to it. But what about conspicuously available email addresses? So I'm assuming like for example, if you went to to IF's website and you found my email address there, is that considered it like available? And what if they are behind some gate like other members of the same association? So like if you found my email, you could probably figure out somebody else's email format, right? Cameron, I hope I'm interpreting your question correctly.
Yeah, so that's a pretty consistently dealt with one. And the answer is you can send and collect that information, and it's considered an implied consent. So it's because it's conspicuously put online, you can use that email to send an email. However, that second part of the question where you're using the form of one to get the other, that isn't going to be covered. That's not implied consent, because there is some sort of extra step that you have had to take beyond the conspicuous placement online. All right, I see more questions coming in.
Okay, so as Cameron said, I got the first part right. Second part was if they were in the same membership list. Oh, okay, so they're not guessing, but they're in the same membership list.
So now I guess there's going to be a follow-up question to Cameron. Is it your membership list, or is it the membership list of a third party?
Cameron, you can also unmute if you would like, and chat directly with Matt.
Hi, Jennifer and Matt. I didn't even realize the unmute button was there. Yeah, the first part was exactly what I meant, is if I were to go to the IF website, see Jennifer's email address, that consent is implied. But if say I had the Chamber of Commerce membership directory, and Jennifer and I were both members, and maybe I wouldn't have that directory if I hadn't paid for my membership, but she's conspicuously listed the email address there. Or I'm a member of the Travel Industry Association. I can log in. It's not a public website, but I can log in as a member and see other members. Presumably we've all signed up. Is that implied consent just as if it was on the public open internet?
Yes, so I would lean towards implied consent there rather than express consent. And so one of the things that we have to kind of cover is that there's time limits on when implied consent runs out. And so in general, specific to your example, Cameron, there's probably a 6-month restriction on that. The difficult part of what you're asking is that they have it displayed online in this membership setting for potentially ever. So, I mean, that's something a little bit different, but I would say that you have implied consent. The key for you is to document that where you got that relationship from, so that if somebody comes knocking on your door and says, oh, no, you shouldn't have emailed this person, you say, no, we have an existing relationship as members of this association, and therefore I feel that I have implied consent. That's going to be at least enough to get you off the hook. They might tell you to, never email that person again, but it'll at least get you past the initial kind of inquiry phase.
Awesome. Okay. So Connie does have one question, and I know this is a simple answer, so we're definitely going to, we'll do this one. So if you're sending a CEM to another country and CASL isn't concerned about it, should we investigate other countries' spam legislations?
So, I mean, that's an international law question. I mean, the answer is, if you're going to be operating in other countries, you should always retain a lawyer in one of those other countries to determine whether you're violating one of their laws. But certainly Canada is never going to prosecute you for something you did somewhere else, dealing specifically with CASL. But yeah, if you have a huge online presence in England, let's say, and the majority of your sales are over there, or even if you just have a part of your sales over there, I would certainly reach out to somebody over there, even if it's just for a quick call, to say, hey, this is how we've operated up to this point. I just want to confirm that we're not breaching any anti-spam legislation in England for the purpose of our example.
Yeah, it was actually my understanding that like it still applied even if you were sending, especially like Europe, because they have that GDPR. I don't remember the acronym. It's like, and that one's pretty intense.
Yeah, it's an equivalent. But as I say, there may be an international lawyer that might be able to give you a better answer than me. But I would always say, always err on the side of caution. I'm a classic lawyer. Err on the side of caution.
You don't say.
Yeah.
We brought a lawyer here, right? So,
yeah.
Okay. So there's one more question, and then maybe we'll let you get back to your presentation.
Sure.
and keep going for a bit. So Jeffrey says, we are working with companies that have contact lists for medical groups, athletic directors, etc., that indicated they have received consent to have us send general emails to the members of this list. They would be cold for us, but the members of this organization agreed to receive broad email campaigns.
Okay. So the only thing that I would make sure to confirm there is, and this is probably with the person that's providing you with this list, is that they really did get express consent for you to send them. Because it's one thing if they say, I've given consent for the association that I've just signed up for to provide me with broad emails. But the sender is very, very important in CASL legislation. And so the other aspect of what we're going to talk about, and I'll kind of go into this, is referrals. And so referrals, and I'll just talk about it right now, actually. Referrals, you're going to need to reference in your original CEM the person who gave you the referral and the purpose of the referral. So I think what you're kind of looking for is, number one, making sure that they actually got express consent for you, and number two, making sure that you refer back to their consent on your CEM.
Okay. No, that's great. Makes sense. Those were really great questions, everybody, and definitely welcome to keep sharing those. We'll let Matt get a little further, and then we'll see if you got any more questions. Matt, I think we left off with you kind of diving into the whole implied consent thing, which I definitely want to make sure we spend some time covering, because it does help you get around those like express, or get to that express point. So it's really good to understand that section. So yeah, thank you.
Of course. So implied consent, we'll go right back into this. Implied consent can occur from usually, well, it has to be from an existing relationship, but there's two different types of relationships. There's an existing business relationship and there's an existing non-business relationship. So for an existing business relationship, there's a couple questions that you can ask yourself, and there's timelines associated with each of those questions in order to determine whether and how long you have implied consent. So the first question is, has the recipient of your CEM made a purchase or lease of goods, services, land, interest in land within the 2-year period immediately before the day the message was sent? All that means is that if they've made some sort of purchase or transaction with you, you have a 2-year clock from that period to send them a CEM. That's implied consent. They have implied consent for you to send them a CEM with their purchase. However, the second that 2 years from that purchase runs out, then you are no longer allowed to send them a CEM because you no longer have consent. The second question is, has the recipient accepted a business investment or gaming opportunity offered by you within the 2 years immediately before the day on which the message was sent? Very similar is accepting an opportunity. Now, that's a little bit more broad and a little bit harder to understand than just a specific purchase. Very easy, transaction, money to money. Opportunity could mean anything beyond, let's say taking advantage of an offer, a free subscription, whether it's a job opportunity, things like that are going to lead to that 2-year implied consent. The third question being, has the recipient made an inquiry or application on any of the items that we just previously talked about within 6 months? So this is really important when we're discussing the empty shopping cart online. Lots of businesses now are having you sign up for an account in order to put items into your shopping cart. And what sometimes happens is you're shopping and then all of a sudden you realize, oh, I don't need this today. I've already spent $1,000 on shoes yesterday. I can't do it today. I'm going to leave this website. And what ends up happening is that company who got your information is going, oh, well, they didn't purchase anything, but do I have consent to send them promotional things? And the answer is yes, but only for a period of 6 months. So it's even shorter than when you actually go through with the purchase. It makes sense logically, but it does give you a very short period of time. So if you are dealing with those type of inquiries or applications, you have to be quick with your CEMs.
I have a question.
Sure, Jennifer.
So I see this all the time, and I know it's something in a lot of ways, some of our very technical clients with very technical innovations or, very B2B products or services. Sometimes it makes sense for them to, use a lead gen tool like a white paper or something. And I see it all the time where it's gated, where you have to provide your email and your name. Is that considered the 2-year purchase or the 6-month implied consent? Which one would that be considered?
So it depends on whether there was an actual transaction where money crossed hands.
Okay.
So
this would just be I want to see the white paper that you wrote about this, or I want access to this guide.
Yeah. So now the one interesting thing is that might actually fall into the opportunity, right? So
Gotcha.
there is ways to go about it.
Cool.
The key in all of this, when you are dealing with the actual enforcement of this, it's always going to be prove it. And so if you can refer to something and you can wave a piece of paper in whoever the investigating party is and say, no, look, I got this. as I say, always err on the side of caution. It's always best to have separate consent things to say, I also agree to get, receive promotions, advertising, marketing. But there's ways to be like, okay, that was close enough, and I know that's kind of a halfway way of saying it depends.
That's fair. But you bring up a good point, even just as an action item, that it's like, consider how you use those lead gen tools to create opportunities for them to expressly consent.
That's
so
correct.
In all of our email signatures, we have like, join our newsletter. In registering for events and stuff. Right now we have Lions Lair happening next week, which is our annual pitch competition. And if you register for that, you can also be like, yes, I would like to join your newsletter list. So like creating opportunities to like enable them to have that opportunity to opt in right then and there is a good way to get past all of those things.
Exactly. And then you're into the realms of express consent, and that's the best case scenario. And so I do have, in maybe about a slide or two, I have kind of some examples of how to do that and how to make sure that you do a separate section for express consent.
Okay, cool. I look forward to that. Cameron has another question. Is it all right to assume that the clock can keep moving forward? That is, if we rebuy or renew a subscription, you keep going with that implied consent.
That's correct. So it's not enough for them to just open your emails, to click your emails. That's not enough. However, if there's another purchase, if there's another subscription, then yes, you have your clock starting over again.
Good. Okay, awesome. All right, I'll let you get back to it.
All right. All right, so I'll go right into kind of how the Canadian government has put out regulations in order to help assist all of you business owners in showing you how you should be obtaining consent. And most of when you're obtaining consent, it's a click wrap agreement like I've got on the screen here. And the majority of the time you're dealing with terms and conditions that you're accepting. The key is that you have to have, it can't be, I accept the terms and conditions and to accept marketing and promotions. That is not proper separate express consent. It has to be a separate box, a separate section where they are actively choosing not to accept certain terms and conditions, but to accept your CEMs. The other aspect of every single message that you send out, it doesn't matter whether you are sending them, the one-off message. It doesn't matter whether you're sending them 100 messages. You always need to have an unsubscribe method. So at the bottom, most people have seen this. You have that at the bottom of your CEM, and it says, I would like to unsubscribe to, receiving this message, and you have to click a link, and something like this should pop up where I wanna unsubscribe from these things. Now, what I've seen recently in the case law is that companies are making it harder and harder to find the unsubscribe option. And what the courts have ruled is, if you make it difficult to unsubscribe from something, that doesn't count. You're trying to circumvent what the legislation is trying to do, trying to give people options to get out. And so what people were doing was, okay, click the unsubscribe link, then you got to fill out another form, then you got to go to another website, then you got to call somebody, and then you got to come back, and then you got to click something. And that was deemed to be not a true unsubscribe option. So very, very clearly, it should be one link to one question. Another aspect to receiving consent, specifically express consent, is you cannot, it's called toggling, is you cannot have a preemptively filled out thing that says, I agree to receive promotions, newsletters, and the like. It has to be an empty one. Now, the reason behind this is that if you were to do this and somebody were to be like, okay, I know that I may have missed this. Well, this only counts as good as implied consent. And so therefore you have that running time clock where, they have, because they've gone through this whole process of purchasing your product and they may not have unclicked something, they have only given you implied consent, which is very key to know when in 2 years' time or 6 months' time that runs up and you're kind of left in a gray zone as to whether you can or cannot send them messages. The other way that implied consent can be given has to do with non-business relationships. And there's a couple ways that can come about. If a donation is given within the last 2 years, you're able to send a CEM. If the individual or company has done volunteer work for your business within the last 2 years, you're able to send a CEM. Once again, these are implied, and so that they only run for those 2 years. And then your membership to a club or association directly related to the business that is going to send the CEM, once again, runs for 2 years. What doesn't count as implied consent is, let's say, there's a company that's running a course, and an individual signs up for the course. That does not come up as either implied or express consent. Another aspect to that is, if, let's say, there is an individual who registers for a course run by a company, and they have a section and it says, I want to receive all of your promotions, marketing, all of those, but they do it in their personal name and not in their business name, it does not give you the right to send their business a CEM, which is very important. So when you're collecting that data, you have to be very careful as to what they signed up as. Even though you may know that they run company X, that's not what they gave you the information for. They gave it to you personally. Okay? When just touching on referrals, just one thing that I forgot is that not only do you have to kind of refer back to the person who's giving you the referral, but you also still have to fit the other requirements, meaning that you still need identification information saying who the message is being sent on behalf of, as well as there still needs to be an unsubscribe option. So it's a little bit more complicated when it comes to referrals. Honestly, the best way when it comes to referrals, and I believe it was Cameron that asked this, was you've got a third party that is giving you a list that says that they have consent. The best way to go about it is that third party sends out the emails to all of those people, introducing them to you. And that's a really good way to go about it and kind of get away from the ins and outs of referral issues. So, I mean, I've kind of droned on for a long while. I'm happy to take on any other questions that people have, and I think I saw a couple more come in. So, Jennifer, hit me with them.
We do have one more. It was about the course example that you gave. So, if someone signs up for a paid course, yeah. Is that a purchase, and wouldn't that start the 2-year clock?
That's correct. So if that's a 2-year clock if there's an actual purchase and it's run directly by your company. If it's an associated company, so sometimes trying to think of a good example of this, but sometimes companies will have a not-for-profit associated with them. And the not-for-profit is dealing directly with an individual registering for a course, and they pay for the course and all that kind of stuff. Well, that does not give company A, who's associated with the not-for-profit, the right to message that person directly.
Okay. All right. So there are no open questions at this time. But you know, I sat in on a bunch of sales and marketing sessions that we've hosted this summer, and you definitely touched on a few things. The cart, for example, the abandoned cart was a great example, and you even mentioned like those third-party sites that like scrape the internet for contacts, and you know, it's a little. I'm sure there's a few frustrated people on this call because they attended like this like sales mentoring session from somebody who's out there doing sales, and this is like a tactic they used to be successful, and but you know, they technically haven't been CASL compliant. So you know, it's, I guess I'm just wondering, is there anywhere we can point them that like can give them some reprieve to like this? Is it just we just have to stick to cold calling to stay in this like safe CASL bubble, or is there anything we haven't considered that might keep us in that, help us navigate through that B2B or implied area to get there?
Yeah, I mean, in kind of a joking way, there are certain aspects to this. There's if you want to fax somebody, that's also an option. I thought that was funny that they mentioned that. I didn't realize anybody was sending spam on fax anymore, but apparently that's a concern. And so, I mean, when we're talking about scraping emails off of other sites, there's no issue with doing that. That's implied consent. But the one thing that you're going to have to confirm with those companies that are scraping emails is that that they are CASL compliant. So when you're scraping that email, so let's say you've got my email online, campbellm@SimpsonWigle.com. If at the same time that I have placed it online conspicuously, I have also placed underneath it, I do not accept any CEMs or any marketing, advertising, anything like that, then that is not a conspicuously placed email. So it's very important when you're dealing with these companies that are, or programs that are scraping emails, is that they're making sure that they're CASL compliant. And the easiest way to go about, you know, covering your own liability is to just take the reasonable steps in order to feel as though you have confirmed that they are being CASL compliant. So, I mean, I'm a lawyer, so I like to get everything in writing. So if you are dealing with one of these sites, send them an email and say, hey, I just attended this session where somebody said, you can be fined $10 million if things go wrong. Can you confirm to me that when you guys are getting these emails, you're CASL compliant? That at least provides you, once again, something to shake in the face of an investigator and say, no, look, I have this email that says I was smart. I knew that I was supposed to be CASL compliant. I tried my best.
So we have two questions, still kind of in this general area too. So what about filling out a contact us form as a cold introduction, because that doesn't use their email address?
So like a contact us in the sense that like a phone number, or like I'm kind of confused on that question.
So Nancy, do you mean like if somebody was filling out the form on your website, and you can unmute if you'd like, if somebody was filling out the form on your own website, or if you were trying to,
Okay, so what
yeah.
I mean is when, instead of sending out an email to a person, I fill out their contact us form for my prospective customer.
Okay,
Oh,
that's an interesting way to
Okay.
get around it. I like it, Nancy.
Yeah.
Loopholes. There we go.
Yeah.
Yeah.
Creative.
So I mean, if you get them to contact you first, that's an existing business relationship right there. I like it, Nancy.
Clever.
Yeah.
Wow, I'm impressed.
Yeah.
So Connie wanted more clarification on the courses.
Right.
So, so if they sign up for a free course, so now there's no exchange in monetary transactions.
Yeah.
You are not giving implied consent to receive CEM unless you actually like put it in there. Is that correct?
So if you gather their contact information when they're signing up for a course, that's taking advantage of an opportunity. So then once again, you're getting implied consent, but it's only running for I think that's the 2-year period.
Okay. So it's, if there's no transaction though, is that not the 6-month period?
So
There's
let me
no
just
monetary?
confirm that for you.
Yeah, no, for sure.
The opportunity, so the registration of a program would be the 2 years. So when it's only an inquiry, when nothing is actually confirmed, that's only the 6 month, whereas the opportunity is 2 years.
Okay. So, okay. Awesome. All right. That was good. Very helpful. Great. Does anybody else have any other questions? You can unmute. We have like 2 more minutes left. Connie, if you want to hang back, we can circle back to that other question you had. But if nobody has any other questions, we can just go back to Connie's question now. And if you have to go, oh, Greg has a question. What are the possible repercussions if an organization is operating against CASL compliances? So he apologizes if this was already said, which maybe you can just give a quick sentence summarizing that.
Yeah, so there's a couple steps to it. The majority of the time you're going to get just a warning email saying stop doing what you're doing, as well as usually an agreement with the Canadian government that says stop doing what you're doing, please agree to it, sign here. And then if things get bad and if there's like some true malice in what you're trying to do and you're really going against it on purpose, for businesses, it can get up to 10 million, and for individuals, it's $1 million in penalties.
Awesome, thank you. All right, so I just want to say a quick thank you to everyone who joined us here today. And if you have any other questions for Matt, you can definitely connect with him. It looks like all his information is right there on the screen right now. And we'll post, if it's okay, Matt, we can share the recording of this session on our website. And so you guys can always check that out later. We have it in 2 locations. We have our COVID resources page where we have lots of our previous sessions on demand. And we also have a page on our website called Resource Listing. So you'll also be able to visit things like that and check out our other previous sessions there as well too. So thank you so much, Matt, for your time speaking today. Thank you everyone for tuning in. I know this was super helpful, like as a refresher myself, because I'm in marketing, so I have to kind of know what's up, but I really needed this refresher. And I hope it was helpful for you guys in navigating all of your sales and marketing pursuits out there. So thank you everyone for tuning in, and have a great day.
Yeah, thank you everyone.
So Connie, if you're still here, we can let other people are going to start dropping off, but Connie, are you still here?
Hello.
Hi, perfect. So let's
Hey.
go back to that one question that we really just didn't get a chance to answer.
About the sending an email, CEM, from a not-for-profit or a charitable organization where there hasn't been a purchase or an opportunity, but it's more of an update or an informational piece.
Yeah, let me just grab it right now.
Yeah. So what if, so you're a charity and you're just kind of blasting out an update on your charity. Where would you be getting these names? Like what list, like what's the source of these contacts as well?
Wow. We get them from all over.
Like, how are you getting them? Like, are you pulling them from the internet? Are they previous donors?
That's what I'm thinking. Like, it could be referrals. It could be, the old put your name and email in here to win a prize at a booth at a table at a consumer show or whatnot. Myriad sources for sure. But I'm just thinking, I know there's the 6-month and there's the 2-month window of opportunity, but they're based upon different criteria, right? There's a purchase and non-purchase. But if we're not asking for money, I'm just wondering if that gives you the 2-year window.
Yeah, so I'm just looking at it now. So it certainly still applies to you, the Section 6 of CASL, but it has to do with what your primary purpose is, and where your primary purpose is raising funds. CASL may not apply. Let's take a look here.
It's always about raising funds.
I work with plenty of not-for-profits, so that's that makes a lot of sense.
But it's just using that soft touch, right?
It's making sure that you guys don't get in trouble as well. Generally, you guys don't have the money to deal with the $10 million penalty.
You got that right.
Yeah. So yes, so you can't do it cold, but it looks like if somebody donates, then it starts the 2-year implied.
Right.
But if you're getting it off kind of third-party sources, like the one that you talked about that kind of is more concerns me is the signing up for a prize. I think you guys should be trying to get explicit within that as well. Is if you're signing up for a prize or a contest that you guys are running, you should have another box down there.
It was there, but probably only within the past year. So I guess I'm just wondering about the names prior to that.
Gotcha.
And I don't really have. And actually, one of my notes was add a field in our spreadsheets to denote the date that we received this email address and the source. But if we don't have that information, I'm guessing just err on the side of caution and not contact them.
That's correct. So CASL came into force in 2014, and there was a three-year grace period where it didn't matter kind of where you got your contacts from. They kind of played loosey-goosey with it, and everything was fine. Now we're past that 2017 date, and so anything that you got kind of after that fact, that's where you're kind of dealing with making sure that you are trying to get at least implied consent. That
makes perfect sense. I guess what I was just, and I know I don't know where the cold emails would come from, but basically, even if you're sending out an update, a touchy-feely update, and you're not saying, please give us money, donate here, yada yada. Even if there's no mention of money, it's still basically, well, of course it's spam, but that is going to be considered it's not going to be considered implied in any way because, well, obviously there's no implied. What am I saying here? It's basically against the legislation to contact.
So what I'll say is for it to qualify as a CEM, it doesn't necessarily have to be the requirement of a transaction. It can be just promoting a specific person or thing, specifically a charity.
Okay, that's where, right.
the induction of you saying, look at how great we are as a charity, look at all these things that we're doing, the eventual goal is always going to be, please give us money after
Yep.
that, right? So
Okay, perfect. Thank you so much. This has been just an absolutely awesome, not just a refresher, but a lot of this information I think we've all probably glossed over a little more quickly than we should have over the years. So this has been awesome. Oops.
No, Connie, I totally get it. It's you know what, it's so there's a lot of factors, and to fully just feel confident that you're doing it well is challenging enough. So and actually one thing if you ever want to do that, like, you know, leave your name for a business for like a draw or something.
Yeah.
One thing we did at a conference was we said, subscribe to our newsletter for the chance to win a prize.
that's a really good way to do it. Yeah.
So they were
like it.
opting in, and
Yeah.
thank you for opting in. Now you're in the raffle. So that was like a little way to get around that and still incentivize people to take that step.
I love that. And it's so subtle.
It's like, you're like, oh, here's my email. Sure, I want to win the prize.
Well, we do it, right? Yes, of course I want to hear of gift certificates to the keg. Yes, please.
Yeah.
Tell me, take my email. This has been fabulous. Thank you so much for your time, everybody. This was wonderful.
Thank you. Have a great
so much,
day.
Connie.
All the best to you all. Okay, thanks.